Hello friends, the controversy of criminal prosecution of Justice Yashwant Verma has heightened and has become a subject matter of great public interest. I am going to discuss the legal provisions of misbehavior and criminal misconduct against the Supreme Court and High Court judges and its legal consequences. Article 124 of the Constitution, more specifically, Article 124, Clause 4, provides for removal of a Supreme Court judge on the ground of proved misbehavior, provided that a motion to that effect is passed by each house of the Parliament by a majority of total membership of each house and 2/3 of the members present and voting. Clause 5 of Article 124 provides that the Parliament may by law regulate the procedure for investigation and proof of misbehavior. Pursuant to Clause 5 of Article 124, Parliament has enacted the Judicial Inquiry Act 1968, regulating the process for investigation and proof of misbehavior. There is no express provision under the Constitution which provides that Supreme Court and High Court judges can be prosecuted for criminal misconduct, nor the Prevention of Corruption Act 1947, being the existing law, had any provisions for prosecuting judges of the Supreme Court and High Court for criminal misconduct. In 1964, the Parliament amended the Prevention of Corruption Act 1947, enlarging the scope of criminal misconduct by introducing the provision that a public servant who has pecuniary resources and assets disproportionate to his known sources of income, which he cannot satisfactorily account for, would fall within the purview of criminal misconduct. But the amendment did not make any provision bringing the Supreme Court and the High Court judge within the purview of this criminal misconduct or within the purview of the Prevention of Corruption Act. It was only in 1991 when the first case, K. Veeraswamy versus Union of India, came before the Supreme Court for consideration whether the judges of the Supreme Court and the High Court can be prosecuted under the Prevention of Corruption Act 1947. The basic questions for consideration of Supreme Court was whether the judges of the High Court and the Supreme Court are public servants within the meaning of the Prevention of Corruption Act. 2. Whether the judges of the Supreme Court and the High Court can be prosecuted under Prevention of Corruption Act. 3rd, who is the sanctioning authority for prosecuting judges of the Supreme Court and the High Court. The Supreme Court held that the judges of the Supreme Court and the High Courts are public servants within the meaning of Prevention of Corruption Act. It further held that the judges of the Supreme Court and the High Court may be prosecuted under the Prevention of Corruption Act. And thirdly, the sanctioning authority for grant of sanction for prosecution against the Supreme Court judges and the High Court judges is the President of India. Currently, the Supreme Court, the judgment further stated that for registering any criminal case against a Supreme Court or High Court judge, the consultation of the Chief Justice of India would be necessary. In the current scenario, the Supreme Court has constituted an internal inquiry committee, and the committee has submitted its report to the Chief Justice of India, who in turn has submitted the report to the President. Whether the President would grant sanction for prosecuting the judge, Justice Yashwant Verma, will be seen in the days to come. What is important, if the government is serious and has intention of prosecuting the Supreme Court judges and the High Court judges for criminal misconduct, then the Parliament should make appropriate amendments to the Constitution and the Prevention of Corruption Act, setting out a robust process and the procedure for investigation of criminal misconduct, and prosecution can be launched against the Supreme Court or the High Court judges. If you like this video, please share and subscribe to my channel.